So good evening, everybody, and welcome to the first series of our Life Empowerment series. This is brought to you by, let me take this. This is brought to you by, on behalf of the church here, but Kim and I have an organization called Strategic Leadership and Coaching Services. And a year ago, we put on this same seminar. We did it virtually. And a lot of people wanted to hear it again, so we're bringing it back and bringing it in live, and also is being recorded. What will happen over the next, starting tonight, over the next four Tuesdays, we will have a different presenter. But tonight we'll have attorney Larry Owens, who's been practicing law here in the state of Georgia since 1975. He will be talking about wills, powers of attorneys, the important stuff that a lot of us overlook. I will say this, that he did the will for us. And honestly, for years, I was real skittish about doing a will, because when you do a will, that pertaining to death, and I ain't want to usher anything in that quick. But honestly, if you don't have a will, even a power of attorney, if you don't have any legal documents of what needs to happen to your affairs, because you never know what may occur. And all of us have heard all of the horror stories of funerals where families were torn apart because of who's supposed to get what and who wasn't supposed to get what. So I think it's very important for us to have this documentation, not only for us, but also for our future generations. Now, the format for tonight, Attorney Owens, he'll come up, speak for about 40 minutes or so, and then we leave it for question and answer sessions, and right at the end, as we finish, we'll turn the floor back over turn it over to Pastor to allow him. If you good tonight? Okay, all right. Well, he said he's good tonight, but some point the Spirit may hit him, so just understand, we'll leave that open. But without further ado, I want to bring to you Attorney Larry Owens.
Well, it's certainly an honor to be here, to kind of give you, for those that don't know who I am, my family moved here when I was born in 1949. A lot of people know me from Owens Sporting Goods. So my family, I practiced law from 1975 to 1980, and then for several reasons. One, we had a thriving family sporting good business, so I helped run that business for 23 years. And in those 23 years, I had to take continuing legal education. And I knew as I got older, I didn't want to do some of the other things I had to do as a young man. So I did my education in real estate matters and probate matters, so that as I got experience, it's like, okay, this is really important and people need to know this. So I've been back in private practice in about 3 months, it'll be 20 years. So, and my practice is in real estate and probate. 3 things I'm going to talk about. First is an advance directive for health care. There used to be 2 documents, and I know y'all have heard of a living will. There was a living will and then a durable power of attorney for health care. okay? And there was also a financial power of attorney. There's still the financial power of attorney, but the two documents before, the living will and the durable power of attorney for health care, if you have one now, they're still good. Georgia enacted, and you can get these at the doctor's office, you can get them at the hospital, you could go online and get them. It's the Georgia Advanced Directive for Health Care. It doesn't matter how old you are, how young you are, good health or bad, there could be a time where you won't be able to speak to your doctor. Okay. Okay. Should I give this up?
Not yet.
Okay.
Just hang on to it for a second. Yes? No.
Yeah, I do have a pocket, I think.
Slide it right there.
Oh, yeah, that one for sure. Did you want me to put this now? Keep going with this. Can y'all hear me? Okay. So the Georgia Advanced Directive for Health Care is in 4 parts, and really say these are readily available. None of these words are mine. This was passed by the Georgia legislature with doctors, lawyers, and Congress going, yep, this is what we need. Part 1 is to pick your agent. This picks the person that you want to be in charge if you can't speak to your doctor. As long as you can talk, you're in charge. But if the doctor goes, for whatever reason, Alzheimer's, dementia, car accident, something, says, does anybody... I can project without this if y'all want me, but I think they want me to. But in any event, so part 1, the key with this is you're in charge until you can't speak to your doctor. And if there comes a time you can't speak, part 1 is picking the agent. And you put their address and their phone number. Phone number is important. They're not going to write them a letter if there's something going on. They're going to call them on the phone. Then there's a place for 2 backups. Your agent could not be available or been in an accident with you, any number of reasons. The power of the healthcare agent is to do anything and everything that they believe you would want done if you could talk to the doctor yourself. And it even says guidance when making healthcare decisions. You're good. We're good there? Okay, thank you. If I need to talk louder or softer, just let me know. So we're good. So when making healthcare decisions, they should think about what y'all have talked about in the past, what you firmly believe they would want to happen. There's also on here where if you didn't want an autopsy for any reason, or it does talk about organ donation. Generally, I don't do anything with the autopsy or organ donation. That's generally a driver's license. And then you can put here that whether you want to be buried or cremated. A will, a lot of people don't have wills, so that, and I'm going to tell you why you probably should have one in just a minute. Treatment preferences. This is the living will part of it. This, I look at 3 things that could happen to you. This talks about 2 of them. You could have a stroke and you could live for many, many years. You may not be able to sign anything, you may not be able to communicate, but that doesn't mean you're going to die at any particular period of time. This treatment of the living will talks about 2 specific things: terminal condition, incurable, irreversible, you're going to die in a short period of time. The other is that you have no brain function. Not that you're in a coma, you have no brain function. Everyone that I do is if that happens to me or that happens to me, you could try to extend your life as long as possible. You could put plugs in you, you could do this, that, or allow your natural death to occur. Don't hook me up to things, and I look at it could be a food plug. They can't, eat or do anything anymore, except as needed to provide pain medication. If you've got cancer and your body's shutting down, and you're going to die, you're going to want pain medication. You shouldn't die suffering. So generally, and that's specific to that cancer that is everywhere, and it's terminal. This then talks about pregnancy, if somebody was pregnant, what they would want to happen. This also talks about guardianship. Generally, guardianship is through the probate court when, for either Alzheimer's or dementia or some other reason, somebody needs to look after your care. So you can put on here that I nominate the person that I chose as my health care agent to be my guardian. Still be up to the probate court, but that's the advanced directive for health care. 6 pages. Key thing though, it doesn't have to be notarized. In fact, there's no place for a notary. You've got to have 2 witnesses. So it's got to be signed by the person in front of 2 witnesses. Witness cannot be the agent, cannot be your health care worker, and cannot inherit from you. Anybody else is eligible, okay? So if you don't have one, look into that. Powers of attorney, financial power of attorney, powerful document. There used to be no rules. It was like people could go get a piece of paper and write out a power of attorney, get a notary, and try to go to the bank and get grandmama's money, okay? And the bank, over years, like, they were put in a bad position. Do we honor this or not? Are we now investigating to see did she really sign it? Is this legal, is it not? Again, none of my writing. There is now passed about, getting old, I'm trying to think, 4 or 5 years ago, statutory form power of attorney, okay? This one not only is, and so the key is when you give somebody a power of attorney over your finances, they can go take the money out of your bank account. So the one thing we've learned a long time ago, if you do not trust your trustee, get another trustee, okay? So remember that. But here you designate the agent. It gives them the full power to do anything. The new one, you can limit it to real estate, stocks, operation of a business, litigation, or all preceding subjects. So if you trust your agent, give them all preceding subjects. Whatever they need to do, they do. Then it's got to be signed in front of a witness and notary, can't be the agent. Agent's duties. The agent has to sign it. That says, if you don't do what the principal expects you to do, if you don't act in good faith, if you do anything beyond the authority granted to you, if you don't disclose your identity, if you don't act loyally and avoid conflicts and act with care, competence, and diligence and keep a record of receipts, disbursements, and transaction, and cooperate with anyone who has authority to make health care decisions and attempt to preserve the principles of state plan as far as you know. And if you don't do that, you have violated Georgia law, okay? So they've got to sign this, and a lot of people don't know, a power of attorney ceases at death. Gone. Some people have used it after the death, and if the bank doesn't know the person's deceased, it happens, shouldn't happen, but it ceases at death. That's where a will takes over. This cites a code section that the liability of the agent, if they do something that they shouldn't have done. And again, they have to sign it in front of a notary. So, powerful document. It's called statutory form power of attorney. There are still 2-page power of attorney. I've got them. Very simple. Says I appoint them, they can do whatever they want to, sign it in front of a witness and notary, and then it's up to the bank whether they go, no, we want this. Okay? So that's the 2 things when people come to see me about wills that we talk about, in addition to the most important thing, the last will and testament. All right. Get a couple of definitions straight.
if you die without a will, then whatever you own is determined by Georgia law. And whatever you own, here is how it goes. Spouse and children, they're first in line. If there is only a spouse, she gets all of it. If there's only children, they share. And when I say children, it's children and children of deceased children. Okay? So if there's were 3 children and one of the children died with 4 children, it would be a third, and a 12th between those. So that's what the law says. Now, the surviving spouse can inherit no less than 1/3. So if there was 1 child, it would be 50-50. If there were 2 children, it'd be a third. If there were more than 2 children, it'd still be a third, and it'd be 2/3 divided by however many other children there were. That's if you don't have a will. And then one of your heirs, and those are your heirs who I just told you. And remember, there's a huge difference between being an heir and being a beneficiary. Heirs are determined by law, and if you don't have a will, they're the sole beneficiaries according to their percentage of inheritance. One of them would have to file to administer the estate. And everybody would have to agree. They'd run an ad in the newspaper. And let's say there was a house, and let's say there was, not stepchildren involved, everybody was in agreement. Then the administrator would convey, and then let's say in this case, there was a wife and 4 children. The administrator would convey the property to the wife and the 4 children. If the 4 children then would quit claim their interest to their mother. Okay? So that would be administering the estate. Now, if you, one big misconception is that if mom and dad own the property together, when mom dies, it goes to dad. When dad dies, it goes to mom. That is not true. That is not true. The way to avoid, because that may be fine. You may be, okay, when I die, it's fine. I want my wife and my kids to have everything, and they love their mom, and they'll do that. That's not always the case. And in most cases, when I start talking to folks, I go, all right, this is what happens if you don't have a will. After I find out who their heirs are. And I go, is that what you want? Probably 9 out of 10 times they go, no, that's not what I want. I go, okay, you need a will. In a will, for the most part, you can do whatever you want to. I tell children all the time, I probably say it, I don't know how many times a week, be nice to your parents, they don't have to leave you anything. Okay? And so, once in a will, and the one thing, people that do have rights are spouses. You can't get mad at your spouse and leave everything to the children and go, he ain't getting anything. Spouses have rights, and that's what's called year support. So irregardless of a will, when you say I do, and you're married at the time of death, there are rights that spouses have that adult children don't have, okay? So, what makes a will legal? And I've got the saddest story going on right now. Woman went to sell the house. I was asked by the buyer to check the title, had husband and wife's name. I called the lady and I said, she said, yeah, my husband died 8 years ago. I said, well, do you have a will? She said, well, maybe, I don't know, I think so. I said, well, I said, did he have any children? She said, they ain't got anything to do with it. I said, did he have any children? She said, yes. I said, well, they're your children. No, he hadn't seen them in 30 years. It's like, okay. Find the will. Please find the will. She finds the will. brings it to me, and it has a notary stamp. Sounds good, doesn't it? No. For a will to be valid in Georgia, 2 witnesses. That's it. The notary comes in to make it what's called a self-proving will. The language of that, where you've got the 2 witnesses. So if all you got is 2 witnesses, that's fine. That's all you need. Be careful being a witness, and also be careful trying to do this yourself, because I'm going to tell you, again, why not. If somebody, and they said, well, I'm not going to tell her I'm going to leave her my house, but I'm going to have her come over and be a witness to the will, and you witnessed the will, and they died, you've lost that house. That becomes part of the residuary estate. Don't witness a will that you might inherit something from, okay? Don't do it. So you've lost that. But, in this case that I was talking about, when I looked at the will with just a notary, that means he died without a will. That means his half interest in the home that had a mortgage, 1/3 of his half went to his wife, who now owns a 2/3 interest in her marital residence, and the other 1/3 is owned a 1/9, a 1/9, and a 1/9 by 3 boys who do not like her. Okay? That story is 1 week old. So, it's important. Some people, I call it vertical. You can be straight up and down, no stepchildren, no estranged children. If it's like I hadn't seen him or whatever, and especially DNA now and all that kind of things. When you do a will, you're in charge. And the only way to attack a will is basically 3 things. It wasn't signed right, meaning, and the basic language just says, nothing fancy, and I want to say that you can go to Staples. You'd be incredible, all the legal documents. You can go to Staples, or I'm sure the other supply places, and you can go online and get all of these documents. But if you don't do it right and end up not having a will, thinking you have a will and you don't, so be careful if you do that. But the basic language says, this is my will, and the witnesses sign it, and then you do what's called probate the will. Probate means you got to prove it. And guess who has to be notified? The heirs, okay? So in the will, there's beneficiaries, and most husband and wife say, I leave it to my wife if she survives me. If she fails to survive me or we die at the same time, I leave it to my children, okay? The heirs at that point would be the surviving spouse and the children. So the children would have to acknowledge and consent to the will. But if they were stepchildren and there was some other underlying reasons, the only way they could attack a will would be basically 3 things. It wasn't signed correctly, there's not 2 witnesses, and it doesn't have the right language. Or she had no idea what she was signing, and I can prove it. Or she was coerced into doing that, they set it up, they brought her in there, and she'd have never done that. Pretty hard to prove, okay? So, 3 things. So I hear it all the time, even in the legal community, where attorneys that don't practice in this get the heir and beneficiary confused. You can be an heir and the beneficiary. You can be the wife and inherit the property. You can be an heir and not the beneficiary. You can be the son and not get anything. You can be a beneficiary but not an heir. You could be a trusted friend but not an heir. So, 2 distinct things. Beneficiary is who inherits your property. Spouses. Years support. Anybody heard about year support? Anybody heard about tax relief? Okay. If you went to a regular, a big box attorney and say, here's the will, I want to probate the will. 9 out of 10 times they'd probate the will. What they don't really explain is that the surviving spouse, male or female, if they own the house together, or even let's say the husband had it just in his name and the wife survived, she can claim that property free and clear of unsecured debt. Unsecured debt, not free and clear of a mortgage. But if there was a big hospital bill that was just gonna bring her to her knees, or a doctor bill, or heck, even a credit card bill that was in her husband's name that she didn't know about, that was gonna go, oh my gosh, that's gonna eat all the equity of the house. That petition is available. Not only do you claim the property, you can claim vehicles free and clear of unsecured debt. You get tax relief on your home for 1 year. Either the year, and you have to do it within 24 months. So if some of you have already done it and go, well, I didn't know about it, or I didn't get it, join the club. Most people don't. When I really made it a priority when I started doing this full time is, and then, it's like everybody ought to claim it. When you use your spouse, doesn't matter if you're rich or poor, doesn't matter what your assets are, the least you can do is get tax relief for 1 year. And all the time I've been doing this, I had one lady that went, nope, I'm paying my taxes. I said, that's fine. I don't have a problem. It's okay. And that was fine. But it's available, but here's the only people that can object are your heirs and creditors. Trust me, the creditors are the tax department. Tax department, this law's been in effect for 80 years, 100 years. The tax office gets a copy of it, they pull the tax bill, you don't have to pay it. Phoebe gets notified, doctor gets notified, Capital One gets notified, and if they don't object, then you don't have to pay the bill, okay? Hadn't had any of those object. The only objection that you can get would certainly not be from your own children. If they do, you'd go, okay, I'm fixing to go do a will, So I tell people, honor your father and your mother. If your mom says sign here, so if they're your children, they're not going to object. The only grounds for objection is she's asking for too much. She doesn't need, because you not only convey the house, which is another savings of money, because if you just probate the will, then you got to do an executor's deed, whereas this is one petition and it does the whole thing. Now, I have had where stepchildren, let's say daddy died and mama claims year support, and he had 2 children that were not hers, they would be notified, and even if there was a will or no will, they would be notified. And 2 scenarios. The only objection they could make is she's asking too much, okay? Let's say there wasn't a will, and it was gonna be a third. And they're gonna go, well, wait a minute. She's now getting the whole thing. I want my third. She's asking for too much. If you've got a will, you can attach it to the petition and say, there is a will, we don't need to probate it, but the will left everything to mama. So how can they object that she's getting too much when she was left everything, okay? So you've got to, it's something that is out there to protect the surviving spouse. It doesn't matter whether it's a man or a woman. It doesn't matter, whether you've got a lot of money or not a lot of money. I think everybody would like to get tax relief for 1 year if they've lost their spouse. And Georgia's the only state in the union that does that, okay? So it's been around forever. I know they said I had a lot of time. I feel like when I talk that I open up a lot of questions. I don't even know how long I have been talking, probably either too long or not long enough. But is it too early for me to, because I'm sure this gave you a lot of food for thought, and it's like, what about this or what about that? And let me say this on a year's support, and I'm going, I can't believe you don't sign this. She got some bad advice. And again, this is 2 weeks old. The only time I've done a year's support, she had a son and she had an adopted daughter that she raised and loved. They're equal. And the father died, and he had a very simple will that says, I leave everything to my wife. And one-page will, had 2 witnesses, nothing wrong with it. And I got her in here, and she brought a friend of hers who apparently had a bad, I don't know anything about the friend. And I said, this gives your mother tax relief. This, one step conveys the property to her. And she wouldn't sign it. She said, I need to go home and think about it and do this, that, and the other. And her mother, it became an issue with them. And it was like, why are you doing this? And I wanted to go, your father did this, your mother is doing this, and you're not honoring either one of them? Okay? So there's a way around it. We filed not only the year's support, but we attached the will that gave everything to her, and we served the secured creditor, the mortgage holder, and the tax department, and we mailed it to this young lady. She has 30 days to object. I've been doing this a long time. She better not object. I mean, it's like, so I know, and the only thing we get, she lost her father, and yes, she was adopted. I don't know anything other than that, but, what I'm telling you is there's, not a will, and spouses' rights and children's rights. So did I open up any questions or and one other thing that may be a thing, I hear all the time, oh, the state's going to take my property. Oh, if I do that. No. Under no circumstances, everybody's got heirs. Under no circumstances will the state take your property. Somebody will step up and prove who the heirs are. And the other thing is estate taxes. I don't have any clients that would meet the estate tax, which I think is $4 million or something. I don't know. So the key is there's not going to be any estate taxes. One thing you might know, because people, and this, since I may have a couple more minutes, is whether to gift your property during life or by will. Say again? And so the will, the basis on the property is what it's worth at death. If you gift it to them in life, their basis is what you paid for it. And then if they sold it and weren't living there, they may have to pay a capital gains tax. So I think the best way for people to get property is through a will. The only thing that can crush an estate is a nursing home. Okay? The thing, they have a 5-year look back. If you want to avoid that, you think at some point you'll have to go into a nursing home, you have to get it out of your name for 5 years. Okay? 5-year look back. No take backs though. Once you give it away, it's gone. But if you own property and you have to go into a nursing home, when they put you in a nursing home, they'll say, does she own any property? Yes. Won't make you sell it. They won't make you do anything at all. But if you're there for 3 years and they've done $100,000 worth of bills through Medicaid, at your death, a letter will be sent from Georgia Community Health that says, we provided this much service and this is what the estate owes us.
Question.
Yes.
You kind of answered it a little bit, but if you could give me a little bit more detail. You talked about whether or not someone receiving property while living versus the will.
Yes.
Because I have an aging father, and
Yeah.
one of the things he wanted to do was to go ahead and gift the property before death.
Yeah,
Even
no.
though there is a will.
Yeah,
that
you could
clearly states.
And I'm glad you said that. So let me say, we call that kind of a lapsed legacy. If you say, I leave somebody my Buick and then you die and you don't have a Buick, they don't get another car. The Buick's not there. So the same thing if you say, I leave my home at 100 South Street and then you gave it away during life or sold it during life, and at death somebody reads the will and says, what happened to South Street? Oh, he gave that away. That's fine. It's just not there anymore. Now, the only thing that the difference would be if you paid $30,000 for a property and you gave it away in life and they didn't use it as their residence. If it wasn't their home and they sold it for $70,000, they would have to pay capital gains tax on $50,000. Now, if you inherit the property, your basis is what it was worth at the time of death. And so generally, if you sell it in 2 or 3 years or 1 year or whatever, there's no capital gains. It's figured whatever you sold it for, that's what it was worth at death. So, but remember one thing, I do real estate too, is your home. If you've lived at a home for 2 or more years during 5 years, there are no capital gains. And you sell it, it doesn't matter how much profit you make on it. There's no capital gains. The assumption is you're going to take that money and buy somewhere else to live. But just remember that. It's, but if you buy something and only live there 1 year and you're going to make $50,000 to sell it, you're going to pay some tax on that $50,000 gain. But if you're going to make $50,000, your taxes would only be 15%, which would be $7,500. You still make a lot of money, but the government would get some.
Last question on that.
Yeah.
Does that still apply to investment properties though, not a home?
Yeah, investment property.
If the deceased owned investment property but gave it during life.
Yeah, if it was given during life and the person is still in life that got it, are they still alive?
Yes.
Okay. Their basis on the property was what the person who gave it to them paid for it. So you can go to the tax card. I can go back to a deed in 1960 and I can tell you exactly what they paid for it. Okay. You can go to the tax assessor right now and it'll tell you what they paid for it. It's called a transfer tax. Transfer tax is $1 per thousand. If I see that a tax shows up of $100,000, that means they paid $100,000. So it's, if you know it, what to look for, that's why they call it the public records. It's, certain things you can't hide. Yeah.
If anyone has any questions here on the floor, I'll bring the microphone to you, and we also have some questions online. Yes, ma'am.
My question pertains to a document called an affidavit gift letter. Are you familiar with that?
No.
Okay.
Well, I'm glad you said that. I want to say what an affidavit is a sworn document that says certain things. I do 2 all the time. One of them is called an Affidavit of Dissent. The other is called an affidavit affecting title. If I've got a certified title and there's something not clear in the record, we can get an affidavit to clarify it. Not really sure of what you're saying, but let me tell you where an affidavit of dissent comes in. But you said an affidavit of gift?
Yeah. After my husband passed, his sister sent this document to the children.
I'm sorry, I'm having a hard time.
Okay. After my husband passed, his sister sent this document to the children. Currently, we are still joint heirs, and I am the executor of the estate for him. And she sent these documents, and also sent copies to the church. For what reason, I don't know. But she sent this document saying that there were properties that they had together, my husband and her, that she gave this property over to the children. And also...
Well, an affidavit won't do it.
Okay.
It would have to be a deed. If she got an affidavit of gift that says, I gift this property to them, that's no good. That ain't no good. You've got to actually do a deed. The deed has to have the correct legal description, and the deed has to have a witness and a notary, two different people. And they have to be signed, all three of them at the same time, and stamped and recorded in the deed records. From what you're telling me, an affidavit of gift, I don't think is any good. But let me, if that, is that?
The names are still, our names are still on the deed, right?
Well, if it's not recorded in the
I have
deed
the
records,
deeds.
then
I have the deeds.
yeah. So, but I would think an affidavit of gift, you may need to hire an attorney to do a title exam. You know, that's what we do. You don't want to buy anything from somebody without checking the title. It can be your next door neighbor or your best friend. They may not know there's a judgment against them. They may not know something, or they may. But so the bottom line is we check titles. You don't buy and sell without an attorney being involved that puts his seal of approval that, yeah, the taxes are paid, there's no liens, there's no judgment, we got a mortgage we got to pay off. So the only way to know that for sure is to examine the title. So, but the two affidavits that are important, one of them's called an Affidavit of Dissent, okay? If death has happened within 3 years and there's no will and there's property involved like land, you have to administer the estate, okay? Don't have a choice. If you want to convey it out of the estate, somebody's got to become the administrator. That's within 3 years. Suppose nothing's been done for 10 years. Happens all the time, okay? And y'all can probably go, yeah, I'm sure it does. So nothing's been done. Let's say it was in both names. It was in mom and dad. Mom died first. Let's make it easy by not having stepchildren involved. Let's do the easy way. Mom and dad own the property together. Mom dies first. Still nothing's done. Then dad dies. Still nothing done. And now over 3 years have passed since dad has died. You do an affidavit of dissent that says you don't have to go through probate. The title standards say you can pass title after 3 years of death with no will. If there's a will, you got to probate, you got to do what the will says. But if there's not, the affidavit would say that the wife died on this date, she was married to this gentleman at the time of her death, and she was the mother of 3 children. It would go on to say that the father died on this date, he was not married at the time of his death, and that the only children ever born to or adopted by him are. And it gives the statement that says everyone is over age and of right mind, and that they're the sole heirs at law. And I'm making this affidavit to put in the deed record so anybody checking title will know who owns it. Super duper document, Affidavit of Dissent. So, you know, that's important if it's gone a long time since death and there wasn't a will. Okay?
Can I say something?
Yes.
Hold on, sir. Mr. Bennett.
I am one of, it was my mother and father passed. And I was chief executive over all of the estates. We owned quite a bit of land and houses.
That means there was a will.
And yes, and we had a will. And my daddy told me, he said, now look, when I'm gone, I want you to be in charge. And I want you to, he said, I want you to be in charge. And so the way I handle our estates, okay, the furniture in the house, we had stove, refrigerator, microwave, all of this kind of stuff. And so what I did, I had them to bid off, to say now.
What's your question? What's your question for him?
Oh, what my question is?
Yeah, no comments. What's your question?
Oh, I don't.
Well, I think I'm kind of hearing what you said as executor, and let me kind of follow that. If your question is, is that kind of the best way to do it? If you're the executor, and I'm going to use my parents. My parents had a will that says I leave everything to my 4 children, boy, boy, girl, girl. And my brother and I, we were the executors, like you. The executor's sole duty is to do what the will says. Now, in this case, let me kind of maybe read your mind on this. The value of items, okay? Money's easy to know what it's worth. But as far as in your case, it may be if it says I leave everything to everybody equally, you have to value the estate and then give equal portions.
Well, what I did, it's like we had a refrigerator.
The question, we only asking questions, not making comments.
Yeah.
What's your question for the attorney?
Oh, I don't have any question. I just wanted to tell them what, the way I distributed it.
I understand.
Yeah.
Yes, sir.
And that's good, as long as you make, the only people then that can object to what you do are the beneficiaries of the will. If they don't think you did something right, then they have an avenue to go to the probate court and say he didn't do what he was supposed to do. So.
But I got something I really wanted. Can I say
No,
something?
we asking questions, sir. We can talk afterwards. Yes, sir.
Okay.
Yes, sir. Yes, ma'am.
The question I have, say I had a will made, like,
Ooh, I'm glad you brought that up because there is something I forgot to mention. Okay, go ahead, because marriage after a will, important, okay? Go
Yes,
ahead.
sir.
All right.
well, my first husband, he's deceased, and I made a will after he passed.
Okay,
So it been, I say, about 15 years.
okay,
So I have my 2 children executors of my estate.
okay.
So do that will still stand?
Absolutely, yes. Yeah, if your husband died and then you did a new will and you said that, and you don't have to say whether you're married or not. You can say, I leave all my property to my 2 children and I leave them as executors. And your will is fine if 2 witnesses signed it.
Okay, I had an attorney to do my will.
Good.
So I got married again.
All right,
So
good.
do I need to get another will?
Yes, ma'am, you do. Okay.
That's what I needed to hear. That's what I needed.
Yes, ma'am, you do. Good question that I had on my notes that got distracted. And guess what number 4 says? If you have an old will and then get married, you will need a new will. Okay? Isn't that about what the question was? So it says, well, let me kind of go into that because it is, the law used to be, if you had a will and then you got remarried and you got married, that it was automatically no good. Okay? Once you said I do at the altar, your will was no good. They softened that a little bit. I'm not sure how long ago. I'm going to guess 10 years ago, maybe not quite that long, that they would try to honor the wishes of the will, but the new spouse gets no less than 1/3 of the property. Okay? But it's way better practice. And you can do something like this. You can say, and You can say, my husband has his own assets and is not to inherit any portion of mine. Okay? And that's well and good, unless at your death he files for year support and says, wait a minute, I ought to get something. Okay? So I've seen all that go, but if you do get remarried, you do need to do a new will. So, yes. Should have asked.
Attorney Owens, would you briefly re-explain the year support and when that actually comes into play?
Yeah. And it is, and it's the name is kind of a misnomer. It kind of gets people off track. What does that really mean? From the date of death, for 24 months, the surviving spouse, whether there's a will or not a will, has the right to petition the court for year support. And in that, you can ask for certain assets, generally the home, whether it's a half interest or the full interest. You can also ask for vehicles, although a lot of times you can get vehicle titles changed, but always if there's vehicles in the deceased name, I go ahead and say, okay, we want his vehicles too. And so that, and then you have to list the interested parties, okay? The interested parties are heirs, same way you figure the heirs. If the spouse died and you're the surviving spouse, the heirs are her children and children of deceased children. If she didn't have any children, you're it. You don't have to notify anybody. But if she has children, then they have the right to notice. It makes it easier if they're your children. If they're not, then they could get ornery, who knows. But then the others is the creditors. The number one creditor is the tax office. We're going to try to get tax relief, and you can either get the tax relief in the year of death, or let's say they died towards the end of the year and it's like, man, taxes are already due, I already paid the taxes, and you can get tax relief for the year after death, okay? So you've got 2 years to claim, 1 year or the other, to get tax relief. The tax office will never object to you getting tax relief for 1 year. Here's the other interesting part. You can only get they tighten this up. People used to try to get tax relief on more than the marital residence, okay? You can really only get it on generally if there's a marital residence, that's where you get the tax relief. But if you had 5 other properties, investment properties or other properties or interest in properties, even in other counties, you can go ahead and claim them. You're just not getting tax relief. You're, saving yourself some money by not having to probate a will that, the what's called the Certificate of Order of Year Support has the legal description of all of the properties you're claiming, whether it's 1 or 5, and it's recorded in the deed records. And the grantor is the decedent, and the grantee is the surviving spouse, okay? So once that petition is filed and the children sign the acknowledgments like, yeah, we don't mind our dad getting tax relief, we don't mind him getting all the property, even if there wasn't a will, they can go, yeah, we're fine with him getting all of it. But then if there is a will, we just attach the will, go, yeah, there's a will, but we're doing it all in this one petition. Ad runs once a week for 4 weeks. Says you've applied for year support. Anybody has an objection, they have until this date to do it. And the judge gives it the Monday following the last running of the ad. Once nobody objects, she signs the final order, we record the deed, done. Good process. But
We have a question from online. What are the pros and cons of a trust and a will?
I will say this right here, and I will say I do not like the word trust. Generally, it's the 2 reasons when I see some maybe to avoid taxes and all. And so when you talk about trust, it generally has to do with some fear of having to pay some sort of taxes. And generally when you talk about a trust, you go find an estate tax lawyer and add a couple of zeros to the bill, okay? So trusts are generally to try to, if you've got generally a major estate, okay? Because otherwise there's not going to be any tax consequences. But here's where I do trust all the time. It's called a testamentary trust. Young couple comes in and they have minor children, 5-year-old, 10-year-old. My will would say, husband, I leave everything to my wife if she survives me. If she fails to survive me, or we die as a result of a common accident or disaster and within 30 days of each other, then I direct that my estate be liquidated and the proceeds put into 2 separate trusts for the health, welfare, benefit, and education of my children until they reach the age of, I generally put 25. You know, it's like, why not? You could pick 18 or you could pick 21. I go 25, that way if they did want to get through school and there's funds there. So that's where I do the trust. And here's the key. Who's going to be the trustee? And I generally, 9 times out of 10, it's going to be one of the young parents, one of their parents, okay, who's going to raise these children. Who's going to, okay, we had a house, we've got $200,000 worth of assets. Once we liquidate it, we're going to put $100,000 for this child. We're going to put $100,000 for that child. They're going to need the funds for different reasons at different times. And hopefully when they turn 25, there'll be some funds there to disperse to them. That's where I use a trust. But as far as something to do with taxes, that's not part of my practice.
Okay. Any questions? Also, if you can think of a question later on, that 3x5 index card that you have, write your question down, get it to us. We'll get it to Attorney Owens, and we'll get you a response. All right? Yes, sir.
I have a question. If a person remarries late in life, and then they already had their house and their land and all of that, the spouse dies, is that person obligated for the bills of that spouse that died, such as hospital, hospice? Or can you send a letter saying that the person passed, had no assets or inheritance by which someone could take care of their debt?
Well, the key is the only time when we talked about that Georgia community thing, that's generally nursing home and Medicaid paying for something. Now, but in this case, with the person in a nursing home or just, no, okay.
The person
just died
a few days before it went on hospice, and so, and had some hospital bills the latter
okay.
days.
All right. In that case, that's where the year's support comes in. Did the person, if the person owned land, did they own, you said they owned some other land?
No, the surviving owned it before marrying.
Okay.
The person who died
Okay.
Actually didn't have anything.
Gotcha.
Yeah.
Gotcha. And you're exact, no, the person who already owned it, the fact that she married and then he had debts and whatever will not affect her property. No, won't affect her property. He did not own her, and she's really not responsible for his debts. she can go, I'm sorry, I can't pay these debts, and they're not her debts. That's when the government looks for assets to go after. And if he doesn't have any assets to go after, that should end it. But yeah, she's, the survivor is fine if the fact of marriage did not vest any title in her property. Okay.
I have a question. If a parent had two kids, and he had a Cadillac, and he have an old truck, now how would you divide that up? If the Cadillac was $50,000 and the truck was $10,000.
Oh, that's easy. Easy. I can divide money in my head. I sell both cars and divide it by 2 in a heartbeat. And if one wants to buy the other one out, let him buy them out. So if the guy wants the Cadillac and he says, okay, I'll take the Cadillac, and he'd pay the other guy $20,000. You know, well, anyway.
No, we're at the end. We're at the end. We don't want to keep you. One thing, sir, people do ask, and we're not advocating for your business, but if somebody wanted to contact you and talk with you, how could they get in touch with you?
Well, let me do it. I'm a sole practitioner. My office is in the Bank of America building downtown, the big old red brick building with the steeple. The bank has left there, so if anybody wants a big, beautiful building, Mr. Corriere has been trying to sell it for a few years. But our office is on the second floor. The building stays locked since the first floor is vacant and vast. And so we're appointment only. My office number is 229-430-9989. 229-430-9989. Now, a lot of times it's better, especially if you want me to look at something or an old will or something. My email is pretty simple. Larry Owens, Law, L-A-W, @gmail.com. I'm a sole practitioner. My secretary has some health issues. During the week, she's still dealing with she and her husband, so we do all of our work on Friday and Saturday. So if you call my office and I don't answer the phone, you'll get a nice recording, and I do return my phone calls. So,
Will you repeat that email again?
My first name is Larry, and my last name is Owens, O-W-E-N-S, and then the word law, L-A-W, @gmail.com. So it is, I say, drafting wills, I do it. It's not, I charge a lot less than the big box folks because I feel like it's that important for folks to have one. And so call me, we talk about whether it's husband and wife or fixing another will or whatever, or if you wanted the advance directive. You know, we have the advance directive. I don't charge very much for that because the key is filling it in right. You know, who do you want to be in charge if you can't talk? So, if anybody's got any questions, I do answer my phone.
All right, well, thank you, sir, for coming out tonight, and we really do appreciate you.
Well, thank you. It was a privilege to be asked to come, and it is important, so I thank y'all also. Thank you.
Thank you. Again, if you think of a question later on, put it on the 3 or 5 index card, get it to myself or Ms. Pursley. We'll get it to the attorney, and we'll get you an answer back. Next Tuesday night, we'll have Luke Strong Jr., the third. He'll be here, and he's going to talk about another topic that we don't want to talk about a lot, but it's about burial insurance and other things that we really need to prepare for when that time comes so that it's a smoother transition. Thank you all for coming out tonight. Make sure we've gotten everybody's information. I bought some candy. Well, she bought the candy, but make sure you take some candy with you. If not, I'm going to eat it all up. And everybody have a good evening.